How do you think about money potentially going to a son-in-law or a daughter-in-law down the road? And is that really securing things the way you want? Hi, this is Jeff Marsacci, the Plain English Attorney, and welcome to the channel. If you haven't already, please subscribe and make sure you turn on notifications if you want to make sure when we release a new video that you're going to get it immediately. Today, we're going to talk about estate planning in a way that might not be what a lot of other estate planners are telling you to think about things. It's just not a prevalent discussion unless the client generally brings this discussion to the professional. All right, so we're thinking a little bit differently because what's very common, what happens if a child passes on before you do? And what I want to get to is, how do you think about money potentially going to a son-in-law or a daughter-in-law down the road? And is that really securing things the way you want? All right, so let's think about that just a bit. Most planners, when they're sitting down with you, they'll go through, all right, so where do you want your assets to go? And a very common answer is, well, I want everything to go equally to my children. All right, what if a child passes on before you do? Do you want their children to get that inheritance, meaning the grandkids through that child? Oh, yes, that's what we want. All right. What if it's not dying in that order? What if everything goes equally to the kids and now suddenly there are these vulnerabilities that are out there? Do you want to protect them from these vulnerabilities, especially where a spouse may be involved? All right. The most obvious one is, what if there's a divorce? So it's very common for especially estate planning attorneys to say, well, look, if your child inherits assets from you, that's not going to be lost in a divorce. And then there's almost kind of like this mumbled caveat, as long as they keep it separate. And I say it's mumbled, it's just simply not remembered. All the client is hearing and all the kids are hearing is, as long as I inherit it, it's not going to be on the table in a divorce. Here's the common situation that I hear. Oh, well, parents passed on, they inherit the money, and then the spouse starts whispering in their ear, hey, honey, now we can get that dream house we've always wanted. We've got the money. Oh, okay. Then they go talk to a real estate agent, start looking around for houses, find the dream house. And the agent's like, okay, you're a husband and wife and you're doing this. And okay, all right, do we need a mortgage? Well, no, we're paying cash for it. Oh, okay, great. Let's get in touch with the attorney then. And they go, oh, well, I got the paperwork. It's for a husband and wife. So this is going to be tenancy by the entirety. And so the house gets bought in both their names. Couple of years later, the spouse takes up with the personal trainer and they're running around. It's like, yeah, I want a divorce and I want half the house. And then the child says, well, wait a minute. All of that money came from my parents' estate. You can't have that. Oh, well, I talked to a divorce attorney and they said you co-mingled those funds. I'm getting half the house. And the reality is they probably are. So that's the divorce situation that a lot of my clients, when we go through things and they see a potential issue with a son-in-law or a daughter-in-law, they say, wait a minute, we want to protect against that. So that's just one potential situation that can cause thinking and planning a little bit differently. Another one is, look, my son-in-law, my daughter-in-law, when they get $5, they'll spend 6. They just can't stop spending money. They're buying all these luxury items. They're spending money on ridiculous things. They're not saving anything. And I need to make sure that there's money there for the grandkids. If they need something down the road, I don't want it to get wasted on my child's spouse and them spending our money to keep them happy. All right, well, there are ways to do that. A third thing is, well, follow this course of events. And this is, again, in thinking differently. You pass on, you leave the money to your child. All right, they end up doing their estate planning. And they go, oh, well, yes, naturally, everything goes to my spouse if I pass on. But if they go first, then it goes to my children. There's a heart attack, there's a car accident, a workplace, something happens and they pass on and their spouse gets all that money. And then the spouse gets remarried. Maybe they're remarrying someone who already had been married and has kids, and now they've got their kids. And then they do their planning and they leave everything to their spouse. So now my clients are in a position of thinking, well, wait a minute, my money could go to my son-in-law or my daughter-in-law, which could go on to their spouse. And then what happens? Maybe their spouse is going to cut out my grandkids in favor of their own kids. That happens a lot. That's just the way the planning is. But there are ways to secure it for the next generation. What about if there are lawsuits, creditors, bankruptcy, something that could be chasing not just your child, but your child's spouse? And now because they're married, these assets may be on the table and attached with liens and all this, and judgments and other stuff, and could end up being lost. We don't want that either. And then the last thing, what if, again, if we're thinking really long term, no issues necessarily with the spouse being a bad person or untrustworthy. What if your child or their spouse is over 65 and suddenly they need nursing home care and they're talking about doing a Medicaid spend down to get their assets to the point where Medicaid would pay for this long-term care? Well, all of that inherited money is also on the table to be spent down and lost potentially. It can be secured. So I'm just going to give you the very basic overall high-level view, couple of sentence plan behind that, the strategy. Instead of leaving assets directly to your children, they're done through what we call beneficiary trusts, or also asset management trusts. It's kind of the same thing. The money's in there. It's secured for their lifetime. And then it has to go to the grandkids. Or if there aren't grandkids from that child, it goes to the other kid's beneficiary trust to stay kind of within the family. And it's not going to go to a son-in-law or a daughter-in-law. And it's going to be protected against those 5 things. So here's the situation again. Instead of leaving the money to your child, it goes into this asset management trust. And then the spouse starts whispering in their ear, hey, now we can get that house we always wanted. And your child says, well, let me talk with the trustee, who's probably their brother or sister. Well, they start looking for a house. The trust can buy the house. The trust keeps that house inside the trust, and as the beneficiary, your child gets to live there. Well, their spouse goes and takes up with the personal trainer and says, I want half the house. Your child gets to say, I don't even own the house. The trust does. And by the way, here are some eviction papers that my sister, as the trustee, put together. You need to get your stuff out within 1 week. All right, that's a big difference. And then when your child eventually passes on, the house can go down or be sold and go to the grandkids. So the son-in-law and the daughter-in-law doesn't have to be in this plan at all. Whether or not it's something where your child dies before you do, it's even if they are passing on after you, this money is still secured for the next generation. So I hope you found that information useful. We do have a course that's just been put up. If you go to inlawplanning.com, you can see where that course is. And we're going to be doing a live webinar in the upcoming months, so keep a lookout for that too. So as I always tell my clients, stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.